Constitution. In view of the fact we have had a number of persons who wish to participate in the workshop, and we have considered extensive comment materials that have already been received, I ask that persons who wish to address the commission during this workshop state who they are and who they are representing, and limit the comments to 5 minutes. The workshop is now open. Prior to public comment, I ask Mr. Schaefer to briefly provide some procedural background as to where we are in this rulemaking process, and I will ask our general counsel to explain for us the substantive content in the memorandum he provided to us, and we'll open the floor. Mr. Schaefer.
Thank you, Chair. Before we move into the substance of the workshop, I just want to give you an overview of where we're at procedurally. And while I'm talking, I think Carrie already is distributing to you all a copy of the amendment, which calls for us to engage in rulemaking. And also included in that packet are copies of the public comments that we've received at our office since the meeting materials were made for this meeting on July 10th. Now, all of what is being passed out to you is already posted on our website. It's already publicly available. We just wanted to make sure that you all had hard copies of it as well. Now, as you know, we're working against the deadline here, given the amendment of having the draft prepared by October 1st. There's 2 things procedurally that I wanted to go over with you this morning that we have to do before we would ever submit a rule for adoption. The first is to prepare a statement of estimated regulatory costs, or a CERC statement. As you can see in the materials already provided to you, several entities have requested that we prepare a CERC about this draft rule. Now, CERCs are statements that are designed to outline the effect of a proposed rule when the rule will either have an adverse impact on small businesses in Florida, or when it's likely to increase regulatory costs in the state by more than $200,000 within a year of implementation. This agency, to my knowledge, has never had to prepare a CERC before, simply because our rules haven't been construed to affect small businesses or impose any type of regulatory costs in and of themselves on individuals or agencies. But the Administrative Procedure Act, which governs rulemaking, if a substantially affected party requests a CERC during rulemaking, the agency must oblige and prepare one. And the statute also says that after we prepare it, we have to do 3 things with the CERC. First, make it publicly available by posting it on our website. Second, provide it to any party who's requested that we prepare one. And third, send a copy to JAPC, the Joint Administrative Procedures Committee, which is the legislative body that reviews the language of all rules before they're submitted for adoption. I put together just some very general notes on what this agency will have to include in the CERC statement, but I'm waiting to actually prepare the CERC until we have a final version of the rule that we intend to submit to the Department of State for adoption. Assuming the Commission finalizes that version today, I'll start preparing a CERC for public review. The only other thing I want to note about the CERC is that once it's prepared and made publicly available, we would have to wait 21 days before we would ever submit the rule for adoption at the Department of State. So the CERC has to be out there for at least 21 days before we submit the rule for adoption. The second thing I want to discuss is if you decide today to make substantive changes to the version of the rule that was presented to you in June. If you decide to make changes that are more than just technical in nature, that are substantive, the statute says we have to file a notice of change in the Florida Administrative Register that is just containing that updated language. And we also have to provide the notice of change to JAPC and give them 21 days to review the changes and provide us with any feedback they might have. So to draw all this together, if you don't have any substantive changes today, and you vote to adopt the version of the rule that was presented to you in June, what will happen is that I'll prepare a CERC, I'll await the allotted 3-week period, and then I'll submit the rule to the Department of State for adoption. But if you have changed today, I'm still going to need to prepare a CERC because one has been requested. I'll also have to prepare a notice of change, publish at the Administrative Register, and give that to JAPC as well for its feedback. I will say too, if you want to view the CERC and any feedback you might receive from JAPC before I submit this rule for adoption to the Department of State, I can prepare those materials for you, submit everything to JAPC and get their feedback, and then present it to you again at your September meeting, which is on September 13th. I think we'll have just enough time after that meeting to still get everything into the Department of State by the October 1st deadline that's been set. It'll be tight, but I think we can do it. I'm happy to answer any questions you might have today about the procedural aspects of rulemaking. And I know that Mr. Anderson, our general counsel, wants to address the substantive content of the rule as well.
Thank you, Mr. Schaefer. Does anyone have any questions for Mr. Schaefer? Mr. Crowell?
Procedurally, if we miss the October 1st deadline, do we forfeit the right to define those things and somebody else defines them?
Well, the constitutional amendment that gave us the authority to engage in this rulemaking does not address that. I would assume we would just continue with the rulemaking process and, of course, the Administrative Procedures Act. I know the legislature is waiting to see what we do so they can start formulating a penalty for this prohibition, though. I think that may have been one of the reasons why that October 1st deadline is in the amendment.
Any other questions, Mr. Schaefer? Mr. Anderson?
Thank you, Chair Zanka. Just briefly on background, not to belabor it, but this matter was up in June, and there was suggested language put forth by the Ethics Commission staff that was in front of the Commission in June. There was extensive public comment at that meeting orally, and there were a lot of things that the Commission has received in writing in regard to that meeting, and also much earlier in this process. We've had, I think, 3 workshops early on. This is another workshop now. We had the comments in June at that meeting. There has been a lot of public input. The language that was presented in June is still before you, commissioners, as something that you have the ability to adopt, or you could, write something from the bench. It is certainly your choice. But the amendment is narrow in what it does for the or gives to the Ethics Commission to perform here. The amendment has a lot of things in it that are self-executing. They go into effect in the future. For example, a 6-year ban on certain revolving door post-employment things. The part of the amendment where the commission has rulemaking responsibility is really very narrow. It deals with defining the meaning of the phrase or the term disproportionate benefit, and then also prescribing or setting forth language as to the intent that is necessary for one to abuse their public position in order to obtain a disproportionate benefit. Now, the language that was presented in June, which is back before the commission again, has various factors in it about the meaning of disproportionate benefit. There are 2 sets of alternative language that are now before the commission that also deal to some degree with those same type factors as to disproportionate benefit. The biggest change from the language that was singularly put forth by the staff in June versus basically 3 versions that are now put forth by staff is, for my own part, I did hear everything that was said in June. I have read extensively things that have been put forth. I heard comments from members of the Ethics Commission at the June meeting, and that has made me feel that it is proper for these alternative language proposals to be before the commission now, in addition to the language that was before it in June. I think that somewhat similar to the advisory opinion process, where occasionally we will have more than one draft opinion that is written. Here we have several versions of language put forth for your use, but of course, you don't have to adopt any of them. But the main difference, I think, between the language from June, which is back again, and the other language, which is here now, also, is that the requisite intent, and I'll call it the June language or the earlier language, stated that the requisite intent for finding a violation of the prohibition in Article 2, Section 8H2 of the Florida Constitution is that the public officer or public employee acted or refrained from acting with knowledge that his or her action or failure to act would result in a disproportionate benefit. Now, at the June meeting, there was quite a bit of commentary and discussion on whether the word knowledge is the appropriate term to use when defining or prescribing an intent that is based on a prohibition that says abuse of office to obtain a disproportionate benefit. The additional language that is here for convenience this time looks to the word abuse and takes from that the notion that when what the law says is that the commission shall not prescribe the intent. It does not say that it shall prescribe the intent for obtaining a disproportionate benefit. It says it shall prescribe the intent for abuse of one's public position in order to obtain a disproportionate benefit. And just looking at the plain language of the provision, in my mind, as a lawyer, and having worked with the commission for many years, thinking about this kind of language, that abuse, in my mind, involves something more than a mere academic knowledge or some recitation of a sterile fact. That abuse inherently has to carry with it some notion of a misuse, a corruption, something wrongful. Essentially, I think there needs to be some sort of wrongful intent associated with abuse and not a mere sterile knowledge that one's conduct would cause or be in order to obtain a disproportionate benefit. Abuse of office is a bad thing. Statutes and provisions that prohibit bad things need and always have had a mens rea. There are certain that involve some sort of wrongfulness and some sort of acting or not doing your job where you have an intent in your mind and you're going about it wrongfully, not just like a drug possession statute where you know you've got a bulge in your pocket and it's pot, okay, you're guilty. I think that the word knowledge that was in the June language can be considered to be an intent and a state of mind, but I personally believe that you need some sort of wrongfulness associated with the mens rea or the mental state when you're talking about abuse, and that's one of the reasons that I have submitted the additional language for you to be able to work with, commissioners. And also, Mr. Schaefer has done great labor refining also some of the points about disproportionate benefit, and there are some issues there. The June language differs somewhat from the alternative language that is before you now. The two new alternatives in terms of disproportionate benefit, they're the same except that alternative 2 does not use the term class, meaning grouping or numbers of people or properties or whatever. It only uses the term similarly situated in that regard and not class. But in any event, the memorandum I sent you that's dated July 10th has all of these things in it. It has different versions attached. I know there are a lot of folks here that will want to speak to this. Certainly, in my view, the plain language is something is the first place to look as to what it means and how it ought to be interpreted. But also other evidence of intent I'm sure will be articulated here today. And I don't want to take up too much time because I know we have a lot of folks that want to talk, but basically, that's what workshops and hearings are about, is to get information from people. And we have gotten a wealth of information, both early on and at our June 7th meeting and since then. And I feel like that it's only fair to give the commission a chance to look at different sorts of language and to help facilitate your decision, which of course is yours, and you can write it from where you want, but I know that it's always good to have something to look at, so that's why we have these things before you, if any of you have any questions for me, or Mr. Schaefer, or whatever, be happy to try to answer them, and I know we do want to move on, with comments from persons from the public. Thank you.
Thank you, Mr. Anderson. Any commissioner have questions for Mr. Anderson? Mr. Cromwell?
Director Anderson, you addressed the question about class, but what about the other comment from JAPSI about changing the language that says an agency may adopt only rules that implement? Does that mean that we're going to have to change the proposed language no matter what happens today?
Through the chair, let me, I might direct that to Mr. Schaefer on the JAPSI input that we had from them earlier.
Committed June 13th.
The letter of June 13th.
Response actually, I'm sorry, the letter came from Sharon Jones.
Yes, that particular letter would like us to put a statutory authority for passing this particular provision, which we have to put at the end of our statutes, section 112.322 of the Florida statutes as well, which gives the commission broad authority to engage in rulemaking. Our intent is to add that when we submit this for adoption.
Thank you.
Any other commissioners have questions? We're going to open the workshop to the public. I ask each speaker to limit his or her comments to 5 minutes. Is there anyone who wishes to be heard? Sir. Morning.
Madam Chairman, members of the commission, I'm Wayne Evans, I represent the Florida Sheriff's Association. We provided a letter to y'all, we're one of the signatories, along with the counties and the cities and the others. I'm going to speak particularly to sheriffs and my clients and the ones that I know most about. And first of all, we, as well as the others who signed the letter, applaud staff for their fine work. We think that the drafts that are before y'all, the alternative drafts that Mr. Anderson spoke about, are an improvement over what we had before. And I guess I'm here to help y'all improve upon the good work. And I want to say this to begin with, and perhaps get the perspective of myself and the others who signed on behalf of their other agencies. For us, the more specific that you can be with regard to the rule, the better we're going to be able to advise our people about what's prohibited and to whom it applies. You know, I'm going to need to go back to the sheriffs once this is all said and done, and I'm going to have to tell them what about this rule amendment is now prohibited that wasn't prohibited before under the code of ethics. What's new and what's different? You know, and of course, that's why y'all are here, is to flush that out. And with regard to disproportionate, to make it very clear so that we can go back and tell our people now what's prohibited. And the other part of that, as I indicated to you before, is to whom does this apply? As we noted in the letter, we think that you could improve upon the draft if you exercise your broad rulemaking authority, like Mr. Schaefer indicated, to define public officer, and you've got a definition that you can use, to define employee, and that's, I think, what's missing, and perhaps a glaring omission. Who's a public employee? I can assume, you know, in a sheriff's office, for example, we're going to have a sheriff, we're going to have deputy sheriffs, we're going to have dispatchers and corrections officers, but what about school crossing guards? Okay, what if there are interns? It would help us if you define employee, and I think you can. It would help us to define public officer, and you could simply, again, regurgitate the definition that's already there. That would give us, again, the ability to go back and tell our people, okay, well, we know to whom this applies now. If you don't put it in, then we have to assume, and I don't want to assume. I would like to have some express guidance from the commission with regard to whom it applies. And if there's a disagreement about whether y'all have got rulemaking authority for that, then I would respectfully disagree. I think you do, and would hope that you could exercise that. The other part of my comment is going to be directed to the substantive part of disproportionate benefit. I was here before y'all at the last meeting, provided a letter then with respect to the similarly situated test. That's in both of the drafts that have been proposed, and I still think that you're going to have difficulties establishing who is similarly situated to certain public officers. And I'll contrast, for example, in the sheriff's office, deputy sheriffs and the sheriff himself. We don't have any difficulty determining who is similarly situated to a deputy sheriff. And in employment cases, for example, the courts do it all the time, other deputy sheriffs. That wouldn't be a problem for corrections officers. It wouldn't be a problem for civilians. But what about a sheriff? Who is similarly situated to the sheriff of Leon County? I don't think a tax collector is, I don't think a property appraiser is, I don't think any of the other constitutionals in the county would be similarly situated to the sheriff. And I don't believe that you can say that the sheriff of Leon County is similarly situated to the sheriff of Broward County, or Jefferson County, or Escambia County. Each one is unique in and of himself or herself. The relationships with the constituents are different. And I think the problem that I have with the proposed rules is that if the predominant test is going to focus on similarly situated, in some cases, you're going to be hard pressed to define who's similarly situated. Can't speak to state attorneys. I don't know if a state attorney is similarly situated to another state attorney. I don't know. I can say with regard to sheriffs, I don't think so. I don't think so. And which is why the language that we submitted to you may be better with regard to looking at this on a case-by-case basis and considering whether there's been an act or omission that's inconsistent with the performance of proper duties. It's in the definition of, I believe there's precedent for it in the statutes. And I think if you look at it on a case-by-case basis, then I think you're going to be in a better position to decide with respect to the relationship between the donor and the public official, whether there's some impropriety there. You can look at materiality with regard to what's being provided. My thought would be similarly situated would be a factor, but not the predominant test. And I think, again, you all would be better served if you looked at it in terms of it being a factor and not the basis for the inquiry.
Thank you, Mr. Evans. Are there questions, Mr. Evans?
Thank you all for your time.
Mr. Evans, I do have a question.
Yes.
Are you the drafter of this revision, or is there someone who would better answer questions about this draft?
Well, I'm familiar with it, and maybe others that might speak to it. There were some provisions of which I was particularly supportive, but you can ask, and if I can answer it, I'll be happy to do so.
I do have one specific question. As the definition of public officer and public employee, how many sheriff employees would fall under to me, these are new definitions, because we have
Yeah.
8 or 10 in the statute.
Yeah, the way this is drafted now, I think anybody in the sheriff's office, whom I would consider to be an employee, not an independent contractor, would fall within that.
Okay, the one that you were supporting.
That we submitted.
Okay.
That we submitted. Again, my concern is if you don't define public employee, I'm not quite sure. You know, again, I don't know about the school crossing guard or the intern or whatever. But the language that we submitted, I would say everybody that's in the sheriff's office, who I would consider, to get a W-2 is going to be included.
And my question is really related because it says elected or appointed to hold office. And I don't know the school crossing guard is an office. That's why
No.
I'm questioning.
No, and you've got public officers and you've got public employees that are covered, correct? For your information, a deputy sheriff as an officer can't have dual office holding. Holds an appointed office. A corrections officer is an employee, is not appointed. So corrections officers, dispatchers, your clerical staff, all of those would be public employees. If you take the definition that we provided of an agency, okay, sheriff's public subdivision, political subdivision of the state of Florida. So with the language that we submitted, basically everybody that's in the sheriff's office who works for the sheriff would be covered.
Great, thank you. Any other questions?
Wayne, I have one question. You made a statement a while ago that, and my question is, why are not sheriffs across the state of Florida similar situated?
Because I don't think you're going to be able to say, for example, that if there was some benefit conferred on the sheriff of Leon County, for example, that you could go and see whether or not the sheriff of Broward County has ever received such a benefit. I think it's going to be unique to the office and perhaps what he has received in the past, whether it's something that would not be expected for a sheriff in the performance of his or her duties. I just don't think that you can prepare them for this. I get it with regard to deputies. I think every sheriff is so unique, and again, I've been working with them since 1993. I don't think it's going to be feasible to find a sheriff who is going to be similarly situated in this given situation. I just don't see how that's going to work. But it seems to me that each one is unique in terms of the relationships with the constituents, and I would be hard pressed to tell you who the sheriff of Leon County is similarly situated to.
I agree with you, they are unique.
We'll certainly echo that.
Further questions of Mr. Evans? Mr. Berger?
In regards to what Commissioner Miggs was talking about, if you're not looking to a similarly situated analysis, can you go through some of the analysis you are proposing?
Well, the language that we submitted, again, focuses, I think, it'll be on a case-by-case basis. It draws from the definition, inconsistent with the proper performance of the duties. Intent language that we provided about wrongful intent, which is comparable to what y'all have here. I think we probably focus on, all right, whether it's something that's been given to a particular public official, perhaps it is, it's a honey safari in Africa, okay? Let's just go there, for example, okay? I think you're going to have to look and see, is there some relationship there between this sheriff and who gave it to him? Are we talking about some citizens that got together and are really thankful for what's been done by the sheriff here, so that it really is a thank you and wasn't intended improperly or wrongfully? Or is there something else here where it's more from somebody who's intending to influence the action of the sheriff? I think that there is going to be some crossover between misuse of a public position and this, in terms of looking at the facts and circumstances. But if you have a test that's inconsistent with the proper performance of the duties, and you have a wrongful intent statute, rule with regard to determining improper intent, you can look at each individual situation on a case-by-case basis, look at all the particular facts and determine, and it may be with regard to the history of this particular sheriff in terms of what he's had before, what's unique to that particular county. And it may very well be with some of them that you're going to be able to define a class like a deputy sheriff. I get very few cases before the commission where I have deputies. The ones that come are usually involving the sheriff, and as I said before, I think really, if you focus on case by case, regardless of whether it's a sheriff or a deputy or anybody else, if you're looking at the facts and circumstances of each individual case, you all will be better served.
So, because sitting on this side of the desk, I feel like we're doing an exercise of statutory construction to come to a consensus of what the best language is, knowing that the best language needs to put someone on proper notice so it's unambiguous and that it's going to withstand scrutiny.
Right.
So when I hear case-by-case basis, my lawyer brain says, well, in every case, there's the statutes, there's the facts, apply the facts to the law. So what I do hear sometimes is totality of the circumstances.
I do, but it would be inconsistent with the proper performance of the duties. That's the language that we provided to y'all. It's already in existing law, okay? So it's something I could explain to the sheriffs, and quite frankly, I think any given public official would understand what's inconsistent, should know what's inconsistent with proper duties, and put an intent standard in there, then I think it would be something that you all could really work with. But let's suppose, for example, you leave in similarly situated, right? I'm not sure how I explain to my sheriffs that this disproportionate benefit means that if you take something and it wouldn't be available to similarly situated sheriffs. I don't know how I explain that, and it very well may be I'm arguing against my best interest. I mean, because if the language is intact, maybe you can't define another sheriff who's similarly situated. I think, again, that what we've proposed, quite frankly, is going to encompass a sheriff better than what's in there. And again, speaking respectfully, of course.
Do you see that as encompassing not just the sheriff, but all?
I'm sorry?
All, not just the sheriff?
I do. I think it would be inconsistent, again, because it's in, existing law already, and it would necessarily focus this on a case-by-case basis.
Commissioner Ray? No.
Let her go.
Okay. Commissioner Leslie?
I'm trying to reconcile your recommendation of inconsistency with proper performance of duties and our charge to define disproportionate benefit. Disproportional, to me, has a plain language meaning that must involve comparison. And I think that is why we have language regarding similarly situated. While I understand your arguments, in my view, can you tell me how that language deals with the notion of addressing the definition of disproportionate benefit?
I think disproportionate can mean inconsistent with the proper performance of his or her duties without necessarily taking into consideration what somebody else has done. I don't think that you always have to look at another public officer to determine if it's disproportionate to that office and this particular individual. I think you can give them latitude to discern what disproportionate means, and of course, it's capable of interpretation. And I think the point that I'm trying to make is that the more feasible definition would be one that focuses on inconsistent and takes similarly situated, that is looking at others as a factor. It may very well be something that you would take into consideration. Maybe as county commissioners, maybe you would look at other county commissioners and see, well, has anybody else received any trip, to Africa? Or has anybody else been presented with, this particular gift? Maybe that will work, and that's feasible, but I think it ought to be a factor and not built into it. I don't think that necessarily you're constrained to find that disproportionate means not available to similarly situated individual officers or employees. I don't think it's that, you're that constrained.
Right, but would you agree it inherently involves comparison to something else? Disproportionate means either too much more than or too much less than a comparable thing. That's the dictionary definition. And so I think what you may be asking of us is to make evaluations that are not what the constitutional amendment asks us to do, which is to define disproportionate, which is the crux of the matter and cannot be a secondary factor, but has to be a primary factor.
Well, a public official has received awards and thank yous and perhaps even gifts before, but not disproportionate look at what's been provided to that official before. And see whether this is so far above and beyond. Could you not focus on perhaps the relationship between the donor and the official to determine that's clearly inconsistent with the proper performance of the duties and therefore is disproportionate?
I would think since the behavior of the recipient or the donor is in question, that would not be proper evaluation.
So I guess my point is I think we've got room there. And certainly because it's capable of interpretation, there are different ways that you could go. The point I'm making is if you focus again on that particular gift, that benefit, that privilege, or whatever has been bestowed, and you look at the totality of facts and circumstances and consider whether it was available to others or not as a factor, I think you'll be better served. I think that's the point that I'm trying to clarify. You all will be better served, and I will be in a better position to advise my clients just exactly what it is that's now prohibited. That's, I guess, the point that I'm trying to convey.
Commissioner Brady?
I'm having some severe conceptual cloudiness on your statement. For me, disproportionate benefit means that there's a group of people. Those people make a decision. In that decision, you find that a subset of those people got better benefits than another subset of people affected by that decision. So in the case of a sheriff getting a trip to Africa, I don't see the disproportionate benefit. Somebody has to do something, a group, something, that says, okay, when we make this decision, some people benefit more than others. And when we talk about the class, we're talking hypothetically about the class that makes that decision. I have conceptual difficulty understanding somebody in mine village somebody in Broward County makes a ethics complaint because the sheriff of Broward County gave himself a better car, and that then we would go look and see what benefit was provided to all of the sheriffs in Florida in terms of a better car. I mean, I don't, and it was in a number of the examples that were presented in the material. I've been here for 3.5 years. I've never seen anything that even comes close to that kind of a jump to faith. So I'm having some difficulty in understanding, because for me, disproportionate benefit means there's a subset of people,
Okay?
and somebody makes a decision that hypothetically they participate in, that said football players get to live, in the Taj Mahal,
Right?
and swimmers get to live in the basement of the gym. And that anybody who would look at that would say to themselves, hey, the football players made out like bandits, and the swimmers in the basement of the gym didn't. And so, I mean, I don't know how you can talk about disproportionate without talking about an effective class, because unless you have an effective class, nothing's disproportionate.
Okay, then you may very well have carved out sheriffs, and I guess that's my point. And thank you. On behalf of the sheriffs, we're good under 112.3139, we're certainly there. But I guess that's what I'm trying to point out. If it comes before you under this new constitutional amendment, and you have similarly situated in there, who is similarly situated to the sheriff of Leon County? I don't know that you're going to be able to determine. And I think, again, that's the point I'm trying to make. If you were going to go with two different versions, and see if I can just bring this to a close, because I know there are others that want to talk. And you have one that would require you to look at all the facts and circumstances that may very well include considering similarly situated. Or you have another that necessarily focuses on determining who is similarly situated. I think in some instances you are going to be hard pressed to find similarly situated. That's my point, and that's probably the best that I can explain it. I don't know if I've been clear enough, but that's the message I'm trying to convey.
Mr. Evans, I have a quick question I want to confirm. As I understand what you're saying, if we took the similarly situated persons as one of the criteria that we consider, you would be okay with that?
I think what I would suggest to you is that you move it to a factor. The language that we've got that's proposed to you it's still going to be there.
Right.
It's still going to be there. It's still going to be a consideration in every case. Whether or not you can determine similarly situated remains to be seen. But again, I would suggest to you, again, that you go with something that is comparable to what's in the corrupt definition to be consistent with the proper performance of duties, have a definition for intent, and you will find yourselves, I think, a more workable rule. That would be applicable to everybody.
Any other questions of Mr. Evans? Mr. Burke?
I wanted to get to your first point as well, and ask you a question on that as far as defining public officer and public employee. Clearly, the statutes in other sections define that, and is it your position that that needs to be specifically defined here, either referencing the other statutes or regurgitating their other statutes? And the second part of that is to both you and our legal counsel, do we have the authority to do so?
Well, we're probably going to disagree on the latter. On the former, I would suggest to you it would be helpful for us to do that. Whether we just cross-reference a statute, whether it's 112.313, for public officer, agencies defined, I think 112.312, if memory serves me correct. And employee, we provided that to you. I think you're going to have to define employee. I don't know that you can cross-reference it. If you can, fine. But it would help me, for example, if I have something particular with a public officer and a public employee, and I can say, okay, clearly these people are covered. Be on notice. I've taken up a lot of your time. I thank you all for indulging me.
All right, thank you, Mr. Evans. The other gentleman right there in the back is